This is Dr. J. Kent Gregory, and welcome to part 3 of chapter 4, Alternative Dispute Resolution. Let's continue on with that, where we left off. We had left off with a discussion of arbitration and the arbitration process to some extent. So now let's get into arbitration awards. So to discuss arbitration awards, there are a few types, or two types. There's binding, right? So an arbitration whose outcome is binding on the parties without the possibility of appeal to the courts. And then, of course, non-binding. So this is where the arbitration award can be appealed to the court. In many states, an arbitration award is converted to a judgment by the court. So then it becomes, officially legal, and then the judgment is a court decision that sets forth the rights or duties of parties to a dispute. So binding and non-binding, and then the outcome or the award is converted to a judgment. So confirmation. This is the process by which a court converts an arbitration award to the judgment that we just mentioned. So it was contemplated by the Federal Arbitration Act and included in arbitration agreements. And most states have enacted versions of either the Uniform Arbitration Act or the Revised Uniform Arbitration Act. So this is the revised version of the Uniform Arbitration Act. So arbitration is an adversarial process, like a trial, and it will produce a winner and a loser. This is quite different from negotiation or mediation, where the goal is for a win-win, where both come out, both parties come out happy. In this, there is going to be a winner and a loser. It's more formal than negotiation and mediation. The parties present their cases to the arbitrator by introducing evidence. So very much like a trial. And after both sides have presented their cases, the arbitrator issues an arbitration award. So there we go. Benefits. Rules related to arbitration differ by state. Arbitration is more expensive than negotiation or mediation, but is still less expensive than litigation. It's faster than litigation, but it is not as private as negotiation or mediation. And arbitrators that are chosen are subject matter experts in the particular legal area of whatever the dispute is. It's a viable option for dispute resolution. Contract disputes between businesses might involve whether goods are conforming or non-conforming under the UCC. So this kind of goes back to one of the things that we mentioned in part one. Uh, Issues of fairness often arise, not often, but we should say do arise in business to employee and business to consumer, so B2E and B2C situations. And parties with unequal bargaining power have entered into a contract that contains a mandatory arbitration clause. So, as you can see, very often business to employee can be an unequal power relationship, as can be business to consumer. Um, if dispute arises and arbitration is commenced, then unequal power between the parties will be an important issue, and hopefully that is resolved by the arbitrator. So some types of disputes that have been subject to mandatory arbitration raise serious questions about the appropriateness of ADR due to the nature of the underlying dispute, like sexual discrimination, sexual harassment, other things like that. So some key takeaways. Arbitration is a form of ADR in which authority is vested into the third party arbitrator. Uh, Arbitration can be binding or non-binding. It may be mandatory or voluntary. And the arbitration awards are confirmed into judgments by the judges. Uh, there have been issues of fairness, questions concerning the appropriateness of mandatory arbitration arise in cases involving issues of civil rights violations. Uh, and the FAA requires, so the Federal Arbitration Act requires enforcement of mandatory arbitration clauses in contract disputes involving commerce where mandatory arbitration clauses actually exist. So some alternatives to ADR that can be put in place by a business to obviate the need for ADR are things like an ethics hotline. So this is an in-house program in some companies that seeks to redress disputes and observe ethics violations before they escalate to permeate the institutional culture, damage a company's reputation, and then rise to criminal or civil offenses. Uh, Open door policy and ombudsman. Open door policy is an in-house policy in which company managers allow employees to bring grievances directly to them. And the idea is to truncate any potential disputes and resolve them immediately. Of course, the problem with that is many employees do not feel comfortable doing that. So there is a drawback to the open door policy or a potential drawback. And then the ombudsman. This is an in-house intermediary or office in which disputes or grievances against a company can be brought. And it investigates those grievances and agrees to work with the parties to resolve the disputes. So some key takeaways as we wrap up chapter 4. Um, Public policy has been codified in the FAA and it's been expanded by the Supreme Court. Um, Change public policy, interest groups can access the government lawmaking power through several points, including through the legislative branch and through the judicial branch. Uh, and finally, to wrap it up, our government's structure allows several points of access for those who would protect the status quo of public policy and for those who seek to change it. The U.S. government is a dynamic system that provides opportunities for special interests to coalesce and change the law and public policy. So that's kind of a larger, big picture of ADR. But again, ADR is a very crucial piece of dispute resolution for businesses. And again, it's often used between businesses, so B2B, uh, businesses to employees, and then businesses to consumers. So very important and time saving and money saving alternative to litigation.